Hello, everyone, and welcome to episode 6 of season 1 of our podcast, Law That Leads. I am with Tanille Turner here today, who is a lawyer and a workplace investigator at Bernardi Human Resource Law. Her experience includes being an appointed member of the Social Security Tribunal, a professional regulatory investigator, as well as a lawyer in private practice. Tanille holds her BA from the University of Windsor, her MPA from Queen's University, and more importantly, she is a fellow alumni of Bond University, where she gained her Juris Doctor. I'm very excited to speak with Tanille today, and she can teach us all about workplace investigations. We are here today with my friend, the amazing Tanille, and we're going to be, in this episode, we're highlighting our employment law practice. And Tanille and I, for those of you that don't know, studied law in the same school in Australia, the amazing Bond University, shout out. Now that we're back in Canada practicing law, Tanille is specializing now in workplace investigations, and I'm so excited you're here to talk to us about this niche area of employment law.
I'm really happy to be here. Thanks for having me.
So, Tanille, tell us, what is a workplace investigation?
Well, the idea of workplace investigations is really simple, but the amount of subject areas and topics that you can investigate is quite varied. So I think a lot of people think of harassment and bullying as obvious things that need to be investigated, but then there are different kinds of harassment, like sexual and gender-based harassment. There's workplace harassment. There's harassment that violates the Human Rights Code. Mm-hmm. And then we also investigate things like bullying and discrimination, breaches of conduct, breaches of policy, general misconduct. So there are a lot of things that can be investigated. And all investigations start with a complaint. That complaint can be anonymous, or the person coming forward can choose to reveal their name. And our job as an investigator is to find information. So that can be through interviewing people, reviewing documents, and all of that is with an aim to try to figure out as best as possible what happened, so that we can give that information in a report to our clients, and then that should cover the information that they need to address the allegations that have been made and make a positive change in their workplace.
That sounds amazing. What would trigger a workplace investigation?
So workplace investigations, they can, or employers can have a legal obligation to do a workplace investigation. That can also happen when they want to get to the root of a specific situation. So again, we talked about those allegations that a complainant may raise against a respondent, the person responding to the allegations. And another thing to consider when determining whether or not you need to do an investigation is when you want to know a specific outcome.
From the employee side, how is the employee notified that a workplace investigation is going to take place?
So typically that depends on the client. So they may choose to notify them. They might want to, we've had instances when an employer has retained us and they want us to make that notification.
Be the breaker of bad news.
The breaker of bad news.
But
I promise I'm really nice and I try to make the process as painless as possible.
And I truly believe that. Let's say, for example, you're the one to say there's going to be a workplace investigation. Do you explain what that entails? Can the employee sort of foresee what's going to happen? Can they prepare for it? What advice would you give to an employee going into this process?
So one of the most important things that I like to communicate to people that I'm engaging with as part of an investigation, if that's a respondent or the person who made the complaint or a witness, is that this process is safe. So a number of times before we meet with our interviewees, we let them know what our confidentiality acknowledgement looks like. So basically it sets out that you are going to, or you're expected to maintain the fact that an investigation is taking place, the questions that are being discussed, the people that are involved. And that protects and preserves the integrity of the investigation. But in also making that a safe space, and a very major value at Bernardi is creating psychologically safe workplaces. It only makes sense that the investigation will feel psychologically safe as well. So even though you are meant to keep all of this information confidential, you can have a support person, you can have legal counsel, you can discuss the investigation with the appropriate person in your organization. So you're not left alone on an island to defend yourself, or as a complainant, you're not left alone on an island to re-traumatize or go through those probably difficult situations again when you're telling it to a stranger. So that's like a key factor in making sure that, again, it's not as scary as it sounds to participate in an investigation.
Yeah, and of course, I think if the employer were to tell me you're going to be part of an investigation now, it does, just the word investigation alone, I think it just carries that
a heaviness.
Yeah, like the scary part of it, those scary thoughts. So have you guys thought about changing it? And calling it something else?
Well, no, and I don't think that's for us to change. There are laws in place that govern workplace investigations, and what's required of them, and what's needed to do them properly. So I don't think we can call them something else.
When a decision has been made, an investigation needs to be conducted. How would an employer know whether to conduct the investigation themselves, or if they should hire someone like yourself to conduct it on their behalf?
So you definitely want to consider hiring an external investigator if you don't have someone on your team that's competent enough to complete the investigation. You also want to look at whether or not, if there is somebody on your team, or like a human resource professional who does have that expertise, do they have the ability to be impartial and neutral? So looking at things like, are they somehow involved in the scenario that needs to be investigated? Could they be a witness themselves to any of the allegations? Somebody that needs to then be a party to the investigation should not be conducting the investigation. And also that perception from the respondent and the complainant that there is any bias could also negatively impact how, again, safe, and I use this term a lot, how psychologically safe they feel participating in that process. So you want to make sure that if within your organization you don't have someone that kind of ticks all of those boxes, then it's best then to look externally to have that done.
So in my mind, an investigation is sort of the last or a last resort when there is conflict in the workplace. But, and I know this, but maybe you can explain to our viewers how the other side of the great work that you yourself do, which result in potentially not having a conflict and not having to do an investigation. So tell us a little bit more about the work that you do, which is more preemptive in nature.
Absolutely. So we do offer training to both employees and employers, so at different levels of an organization, whether it's employees or management. So that can look like training sessions that are developed specifically to help supervisors or managers create harassment-free workplaces. Some of the training that we offer on the employee level can include sessions on inclusion bias, anti-racism, respect in the workplace, and basically how to create positive work environments. So another service that we offer at Bernardi outside of investigations and training are culture assessments. And those are a great way for management to be proactive in terms of making sure that the workplaces that they have are fostering positive dynamics. So I talked about investigations, where they start with a specific complaint. Perhaps the employer has an obligation to investigate, and you want to find out the facts of what happened in a specific scenario or situation. Cultural assessments are more broad, they're dynamics driven. And what those look like are, we issue a survey, so it goes to a broader section of the organization, if not the entire organization. We do interviews, so those could be one-on-one, they could be in focus groups. And then we prepare a report that summarizes key themes and findings about the nature of that workplace, but we also provide recommendations, and that's another major difference. So with cultural assessments, it also puts the onus or pressure on management to put those recommendations into effect to improve that workplace. There are more people holding management accountable because everybody participated in it.
Right.
They're receiving a summary of both the findings and the recommendations. And there are more people involved than just, say, a complainant and a respondent. So it has a much broader impact than an investigation, which is a lot more narrow.
But once the cultural assessment is completed for one of your clients, do you keep in touch with the employer to see how those recommendations are being implemented? Do you offer any other sort of services along the way?
So some of those recommendations may include training that we offer. If there are overarching findings that speak to specific conflicts in the workplace, so perhaps there are it could be one person might create a number of issues for a lot of people. It could be a lot of people create a number of issues for a lot of other people.
Right.
So we do offer the services that can help you take your work environment or your workplace from good to better. Speaking of training, we do offer training for professionals as well as our clients. So that looks like the Workplace Investigation Certificate Program, and that is offered through the Human Resources Professionals Association. And then there are two other programs through Osgood, the Advanced Workplace Investigations Certificate Program and the Workplace Mental Health Certificate Program. And all of these programs are co-chaired by lawyers at our firm.
That's amazing. And is there any other workshops that are coming up that our readers, if they're more interested in what you do, is there any workshops or anything online that they could sign up for?
Absolutely. So we do have an inclusive workplace series. Our next episode is going to be on March 20th. It's a free live lunch and learn, so you can register at our website, which is hrlawyers.ca. And the subject matter will be truth and reconciliation in the workplace.
Going back to the investigations, what can an employer expect from the investigation process?
When you are hiring an external investigator or coming to Bernardi to have a student investigation for you, you can expect that we have a team of investigators that have a wide range of expertise and are very impartial. And our goal is to conduct these investigations fairly. We do set out in the initial conversations about the investigation what's called a terms of engagement. It's like a retainer, and it sets out the scope of the investigation so that you take the lead as the client, and we're then looking into the issues that need to be addressed within your organization. So each organization is customizable and tailor-made to whatever the needs of your organization are.
I see.
When we're discussing the terms of engagement, that could vary from perhaps you just want us to look into simply do these allegations look like they amount to harassment?
Mm-hmm.
And that would be on the face of the allegation. So we call that a prima facie assessment. That's
Okay.
simple. That can be done a lot more quickly than a fulsome investigation that might be based in the breach of a law or policy within your organization, and if you want that legal analysis to be done.
I see.
The investigations themselves, as I mentioned before, they're fact-finding missions. So they involve interviews and document review, and we provide a report. We try to make sure that, much like your audience, not all of our clients are in the legal field. So we need to make sure that those reports are in plain language and accessible and easy to digest as possible.
And what happens in the event that during the investigation process, the employee has their own legal counsel? How does that come into play in your investigation? Do you just sort of say, thank you, we know who you are, thank you for your email, you have to wait until the investigation is over, and then we can communicate with you, or can that hinder your investigation process somehow?
It doesn't necessarily hinder the investigation process, but that if it's a witness, if it's a respondent, if it's the complainant, if they want to have legal counsel for the investigation, they absolutely can.
Okay.
They can act as a support person. When we're interviewing people that have legal counsel, their legal counsel may choose to be present. So whether that's online on Teams or in person in our office or somewhere we need to meet that's mutually convenient for everyone. And the only difference is you may think that, well, my lawyer's going to answer my questions for me.
Right.
That can't happen.
And I think that's where I was starting off when I asked you my
Yeah.
question, because I can imagine a certain situation where the person doesn't want to answer for whatever questions as part of your investigation, and then is now in a position to hire counsel, and then think that they would be able to hide behind that. But I guess in your investigation, how would you compel those answers?
Well, it's funny that you use that word, because we can't. We can't compel someone to answer or even to participate. So their participation is voluntary. And if their lawyer is there, they may want to sort of and give them a little wink and a nudge. But it's still my job to get that information out.
Right.
So how can I make you comfortable enough to be candid and to be honest and to give your whole version of the story?
Right.
Because part of making people feel comfortable in their interviews and discussing the confidentiality acknowledgement and all of that is during an interview, and this may be something that's unique to the way that Bernardi conducts their investigations, we draft a statement. So you'll be talking and I'm writing down what you're saying, but I don't then print or mail or email that document to you. So we'll be in the room or online on Teams, and I'll either share my screen so that you can review your document and make sure that it's captured everything you intended to communicate, or if we're in the same room, I'll print it off and show it to you, and you can, make the requisite corrections. Nothing that's going to totally change what you've said previously.
Right.
But this says she and I meant he, or something like that. So that document is actually for my eyes only.
I see.
So that may help to disarm you and feel more comfortable in sharing this, because when I prepare my report for a client who is most likely your employer, they don't see that raw document. They don't know what Paula said word for word. I may refer to it, I may quote it, but that isn't going anywhere. So it's not for the world to see.
And how does that change between an employer that is diligent and wants to have an investigation versus an investigation that is mandated by law or the court that it must happen?
So the way we conduct our investigations doesn't change.
I see.
But a client may determine how detailed, perhaps which allegations should be investigated. They bring that information to us.
Yeah. Now that we're talking about this, I remember this one instance when I was practicing condominium law and my client was the condominium board.
Mm-hmm.
And we had a situation where one member of the staff made allegations against one other member of the staff. And it was a situation where at the end of it, it became a he said, she said situation. And there was, sometimes you don't have this concrete evidence that we require.
Mm-hmm.
So when you have a situation like that where it's nearly impossible to get the evidence that would be conclusive as to what happened, how do you then either shape your report when it comes down to two separate people's version of events and they quite differ from one another? Or does that change your investigative process into how you would treat another situation where there is this concrete evidence in between and you're able to rely on that?
I don't think it would change the investigative process or the way you approach that investigation to have two conflicting versions of events.
Okay.
What you then need to turn to is an assessment of credibility for both of those parties. So is one person, for one reason or another, more credible than the other?
Mm-hmm.
Have they been consistent in the way they've provided information? Has there been anything else to support that information? There are a number of other factors to assess credibility where that kind of helps you to tip the scales as to making a finding. And our report findings are based on a balance of probabilities.
Okay.
So is it more likely than not that this happened or not?
Right, not just family law.
Mm-hmm.
And in family law, you almost have to be aware of different cultural norms and how certain marriages would be gender-based, like gender-based roles, traditional roles. Or there's other cultures where either that doesn't exist or somehow it's treated differently, right? And an event happens that could cause trauma. It doesn't necessarily, most of the time, it's something violent to create that. But in family law, what I've learned is that when you spend a little bit of time understanding what happened from a trauma-informed mentality, and also spending a little bit of time to understand that if this marriage did not happen in Canada and these two individuals arrived here after the marriage and they already sort of had a way of living together for so many years and now they're in a new culture and they're getting divorced in the new culture, obviously that's going to be impacting them where they come from, what their norms are. So if I were to do a little bit of research, or if I were to take a step back and understand how different a traditional Canadian marriage might be from that, and also being trauma-informed, it would definitely change the way that I understand the situation, right? And the reason I come to this is because I've had to learn over the years that with family law, there's also law enforcement involved. And if the person that has suffered an event calls for help, even the way they're calling for help sometimes could be misinterpreted because of either trauma or being in shock or whatever a point in time that event is. So I've learned to look at things from a different perspective, whereas in law school we're taught very clear cut, and you're sort of you're focusing on the facts, you're looking at this, but sometimes the way that people react to a certain event is very different from one another. And even though it could appear a certain way, it might not be. And it all comes down to cultural norms. It all comes down to how you react to that event.
Like
where you're taking all these factors into consideration, but you're also protecting the investigation process from something being misinterpreted because of someone's background or cultural norm.
So it's interesting you bring this up because we just had a meeting about how to draft our allegations. One, in order to capture what the complaint is, but two, also not to back ourselves into an investigative corner.
Right.
So for example, if you, Paula, allege that I, Tanille, said that your hair looks stupid, then, or dumb. Tanille said my hair looked dumb. So my allegation, as I'm drafting it, could be that you have spoken inappropriately to your coworker. For example, said that her hair looked dumb.
Right.
And so that allows me then to if I'm interviewing other witnesses, has Tanille said that your hair looks dumb as well? Or made other inappropriate comments, I then can see, okay, she has said things like this before. This is just an example. If the allegation is just, Tanille says your hair looks dumb, what if you said your hair looks stupid? What if you said, I don't like your hair color? Well, that doesn't really address the allegation, does it?
Right.
But further to your point, in terms of considering where people are coming from, what if I have an accent and I said, oh, your hair looks yummy, I love it, or something like that?
Yes.
What if that was different? Or what if dumb is like slang for really good? Like, your hair looks dumb today, girl. Like, who knows? Like, it's just an example. But like that, that then gives some weight to what the person said and how, what that means too. The intent doesn't necessarily matter if that's still what you said, but it is a factor to consider when you're looking at where people are coming from and how they're communicating and what got them there. So even if I was just like, yeah, your hair looks dumb, and that's supposed to be a compliment, it doesn't matter. But at least I know, and I can include that in my report to the employer, oh, this wasn't intended to be insulting or a breach of conduct or an inappropriate comment, but it did happen. Right. So that then becomes a learning opportunity for that person that perhaps you don't need to use that word next time, not in the workplace.
It's so funny that you say this and the example that you used, because I remember when I was in law school, the first time I'd heard this, someone actually said, you look stupid cute.
Right.
And to me, the word is...
I am in law school and not
It's, you associate certain words with certain either like positive or negative connotations. And then when a person is using it outside of what you're used to, you sort of take a step back and you think, oh, wow, it can mean something else. And it doesn't actually mean what I thought my entire life or what I thought was normal. And now it's someone else using it in a different context and it's not so normal.
Right.
So.
But at the end of the day, you probably don't need to say that to somebody that you don't know. And you probably don't need to say that kind of thing in the workplace. So maybe just avoid the slang in general and keep the communication really clear.
That's a very good tip. Well, Tanille, thank you so much for coming. We had an amazing conversation. I hope our listeners learned a lot about workplace investigations and some of the training that you do. And I hope everybody signs up for the March 20th webinar.
Thank you. I appreciate you having me here. It was a pleasure.
This podcast is brought to you by ALF LLP. Save the 17th of each month for new episodes of Law That Leads. Connect with us on social media for updates and exclusive content. You can find us on Instagram, LinkedIn, YouTube, and Facebook at ALF LLP.